Good afternoon. I'm going to go ahead and call this meeting of the Senate Committee on Growth and Infrastructure to order. At this time, if we can have the secretary call the roll.
Senator Buck, Senator Hansen, Senator Doniate, Senator Pazina,
Present.
Chair Wynn.
Present. And if we can mark Senator Buck present when she arrives, as well as Senator Hansen. Today, just to give you a layout of the land of what it looks like today, we have quite a few things on work session. As you can tell, some people are in other committees, including myself, so we will be doing those at the end. Maybe in the middle, maybe. So that's the best I can give you. I know there are quite a few people here that I don't believe are here for the bills that are being heard today, but I do know that they are likely here for other things. With that being said, we will move into our first meeting. Kind of going to take these, nope, I'm not taking them out of order. The first one, I'm going to open up the hearing on Senate Bill 304. And call Senator Stone up to the table. I believe he has Mr. John Jones from the District Attorneys Association here to help present. Because of the long agenda that we have on today, I hate to do this, as everyone knows, because I love a long meeting. When we get to testimony, we will likely limit testimony to 15 minutes in support, 15 minutes in opposition, and 15 minutes in neutral, just so we can make sure we get through the extensive nature of all of these things. And with that, I will turn this over to you, Senator Stone, to begin. And if I do have to step out to go into another committee, I apologize. And if that's the case, I will turn this over to Senator Pazina.
Wonderful. Chair Wynn and committee members, I'm Jeff Stone representing Senate District 20 from Mesquite, including Henderson, south to Laughlin. It's my pleasure to present Senate Bill 304 relating to vehicular homicide and providing other matters properly related thereto. Joining me at the table today is John Jones, Chief Deputy District Attorney with Clark County, and in Las Vegas we have Eric Bauman, Chief Deputy District Attorney, Team Chief Vehicular Crimes Unit, again with Clark County. SB 304 aims to revise the elements required for a person to commit the crime of vehicular homicide in Nevada. The bill removes the requirement that a person must have been previously convicted of at least 3 offenses to be charged with vehicular homicide. This change simplifies the criteria for charging someone with vehicular homicide. Under existing law, a person commits vehicular homicide if they drive or are in actual physical control of a vehicle while under the influence of alcohol or certain substances, proximity caused the death of another person while driving, have previously been convicted of at least 3 offenses. The revised law under SB 304 will no longer require the previous conviction of 3 offenses, focusing instead on the act of driving under the influence and causing a fatality. The bill notes that there's no fiscal impact on local government, but there is an effect on the state. The bill allows for an affirmative defense if the defendant can prove by the preponderance of the evidence that they've consumed alcohol after driving and before their blood or breath was tested. I would now like to turn it over to Clark County District Attorney's Office for further testimony.
Thank you, Chair Wynn, members of the Growth and Infrastructure Committee. My name is John Jones here on behalf of the Nevada District Attorneys Association. Again, as Senator Stone indicated, with me down south is Eric Bauman. The Senator did a great job of explaining what SB 304 in its current version does. I will note that we have, as the Nevada District Attorneys Association, sponsored an amendment. That amendment deals with 484C 430. Right now, there are 2 DUI death statutes. The first is 484C 430, which is our current DUI death and combined substantial bodily harm statute. The second is 484C 440, the vehicular homicide statute that Senator Stone is proposing to amend today. Because SB 304 removes the element of having been previously convicted of at least 3 offenses, this causes SB 484C 440 to also become a DUI death statute. So now we have 2 statutes prohibiting the same conduct with different penalties. So what my amendment does is it strikes the word the death of from 484C 430, making that statute a DUI causing substantial bodily harm statute only. Thus, 484C 440 would become the new DUI death statute in Nevada, and 484C 430 would become the DUI substantial bodily harm statute. Just for the committee's reference, the penalties under 484C 430 are currently 2 to 20 years in the Nevada Department of Corrections. That would not change when it becomes the DUI substantial bodily harm statute. The real change would come with the penalties associated with a vehicular homicide, and that's why we're bringing the statute today. The effect of this bill is to increase the penalty for DUI death from 2 to 20 years to a set term of either 10 to life or 10 to 25 years. And it would be up to a judge to determine which of those penalties to impose. This bill recognizes that the conduct and result between DUI death and DUI and second-degree murder are virtually the same. And that is the policy reason for us bringing this bill. In Nevada, a second-degree murder is a murder committed with what we call an abandoned or malignant heart. In layman's terms, what that means is it's a reckless indifference to human life. And it has been the position of DAs throughout the state that getting behind the wheel of a vehicle while intoxicated and proximately causing the death of another meets this threshold. Thus, our position is that DUI death should be punished similarly to second-degree murder. Chair, with your permission, I do have Eric Bauman in Vegas, chief of our DUI team, to present more policy reasons for the change.
Thank you. And just for clarification for committee members, you are presenting based on the amendment that was uploaded to Nellis and that's available here, I believe, in the committee room as well as to all of our members. Hopefully have that copy. And then I'm looking at the amendment as proposed, and I don't see that language regarding the new additional penalties. Am I missing it somewhere in this document, or is there a separate document that has that information?
John Jones on behalf of the Nevada District Attorneys Association. So 484C 430 and sub F, we're striking out the death of, and the penalty is prescribed as 2 to 20 years. In the original bill, section 1, the penalties for this statute, I don't believe are in the bill, is a 10 to 25 or 10 to life. So that's a separate NRS that's not affected by any change that we're making today.
Thank you. I just wanted to clarify. Thank you. Go ahead and
Hi, my
begin,
name
Mr.
is
Bauman.
Eric Bauman. I'm with the Clark County District Attorney's Office. I'm the Chief of the Vehicular Crimes Unit. Madam Chair, members of the committee, thank you for this opportunity. We all agree that the number of DUI fatalities in our state is far too high and has been for far too long. We're past the point where education is our goal here. The people, they know what the dangers of driving under the influence are. At this point, we have to recognize that this is a choice that is being made, a willful choice, tantamount to firing a gun into a crowd when you get into a vehicle and choose to drive while impaired. This bill recognizes that we must treat this crime with the requisite seriousness to penalize people the same for what this conduct is, which is tantamount to second-degree murder. Our state has an opportunity to take a leadership role here and have among the toughest penalties in the country for those who take the life of a person while driving impaired. The flip side, I think, that is an important consideration is that too often in prosecutions for DUIs which cause very grievous bodily injuries, injuries like paralysis or amputations that people have to live with for their entire life, we find that during sentencing that years are taken off the top of the sentence because it's the statute as currently stands is combined with DUI causing death. So the maximum sentence is almost never applied to these injuries. And we feel that people who are victims of DUI causing substantial bodily harm will have a more fair hearing. Thank you.
With that, Chair, I believe we're available to answer any questions.
I have one question. When we look at the original language of DUI causing death or substantial bodily harm. I see that in your proposed amendment, you are striking out the death of or part, so it would just be a DUI substantial bodily harm. I see that the penalty has not changed. Was there any consideration about that? Obviously, when that penalty is imposed, it has a very large range. And I think that was probably, and I haven't looked at the legislative history, but I'm assuming because on the low end, you have 2 years because it also encompasses perhaps like a substantial bodily harm claim. And then on the high end, I think it was probably taking into consideration a death. Was there any indication or any conversations about lowering that 20 in light of the fact that you're taking out the death?
John Jones, on behalf of the Nevada District Attorneys Association, we have had conversations with the public defenders about that. And obviously, Chair, we're open to any conversations with respect to this bill. We have two main goals with respect to SB 304. One is to separate substantial bodily harm and DUI and not have them in the same statute. I think Mr. Baumann indicated why having them in the same statute with the same penalty is causing problems. The second is to increase the penalty for a DUI causing death and make it more akin to second-degree murder. Within that, Chair, we are willing to have any conversation. But what I can say is that substantial bodily harm encompasses a wide range of potential injuries. It could be a broken leg, where somebody suffers extreme pain for a prolonged period of time. But as Mr. Baumann indicated, it could also be somebody who is a paraplegic for the rest of their life. So the fact that we have a wider range, I think, gives the court more discretion to appropriately punish the behavior based on what the outcome of the actions were.
I guess my second question, I feel like I'm in judiciary, which I am simultaneously right now. But I guess my question is, when it comes to, obviously, in the way Senate Bill 304 was initially drafted, it was kind of this creative language to get to the penalty that you were looking at. Was there ever any kind of indication to just separate this within the existing DUI statute to have DUI death, DUI substantial bodily harm, and lay out those particular penalties as such? And I think, like in the governor's recommended criminal bill, policy bill, that's kind of what he has done. So was there any consideration of that, or was that just, this was an existing statute that had the penalty range that you were looking for?
Thank you. John Jones on behalf of the Nevada District Attorneys Association. Chair, we are actually open to either of those. I do appreciate you mentioning the governor's crime bill. That does take a different approach than what is contemplated currently by SB 304, and we are happy to have a conversation. I think either of those approaches moves us in the right direction.
So is that my understanding that you would be open to a DUI death and a DUI substantial bodily harm separate statutes? And I believe that, and I don't have it with me, but I believe the other recommendation, just to be, I guess, consistent across some of the legislation that's currently pending before the legislature, I think the recommendation was it 2 to 25?
John Jones on behalf of the Nevada District Attorneys Association. In the governor's crime bill, which I believe is SB 547 for the record, but that could be wrong. It splits out within the same statute, but it does separate the punishment. So DUI substantial bodily harm would remain a 2 to 20, and the punishment for DUI death would become a 5 to 25. So there's a larger range in there. But I must also say that the governor's proposed crime bill goes a little bit further, and then it allows a prosecutor to file second-degree murder when extreme malice is present. So there is also the ability for more enhanced punishment when we have the more extreme conduct.
And then just to get into, I understand the reasoning and the intent behind what you're seeking to do in Senate Bill 304. I think you can't live in the state of Nevada, and I know that you can't be in southern Nevada in particular, and I'm sure it is similar both in our rural communities as well as up north, seeing some of these particularly egregious DUI cases that have resulted in multiple deaths under horrific circumstances. So I think we understand, I think probably everyone agrees with the intent behind this. Can you kind of discuss some previous litigation that you've run into trying to charge these DUI deaths with second-degree murder?
Thank you. I can touch on that briefly, and then I might punt down to Mr. Baumann. But there has been substantial litigation around this issue. But what the Supreme Court has said is that when the legislature prescribes a specific penalty for specific conduct, then we are limited to only charging that particular crime. So because we have a specific crime in Nevada for DUI death, we cannot charge a DUI death as open murder. And the most recent case that decided that was Lavelle versus the 8th Judicial District, the citation being 135 NEV 676. So, Chair, there was a time when we were charging the most egregious cases as a murder, second-degree murder, but the Supreme Court has said because the legislature has prescribed this specific DUI statute, we can no longer do that. I don't know, Mr. Baumann, is there anything you wanted to add?
Sure, if I may, since I was personally involved with the Lavelle case, I think it might be instructive to give the basic facts of that case. This was an individual who was significantly impaired by marijuana. He was driving at over 150 miles an hour in a 25-mile-an-hour zone and struck and killed someone. So that was the egregiousness of the level of behavior that we attempted to proceed under the second-degree murder theory on. And that was, the Supreme Court said, you have a DUI death statute, you have to use it.
Thank you. Do we have any other questions from committee members? Seeing none, thank you for your presentation, and we will begin with testimony and support. At this time, I am going to turn the meeting over to Vice Chair Pazina. So if there's anyone to testify in both Las Vegas or in Carson City, I'd ask you to fill in those chairs. And I see people moving through the very crowded room that is in here. I'll go ahead and turn it over to you.
Good afternoon, Chair Pazina and the Committee on Growth and Infrastructure. My name is Chris Reese, it's R-I-E-S. I represent the Las Vegas Metropolitan Police Department. First, I'd like to thank Senator Stone and my colleague, Mr. Baumann, from the Clark County District Attorney's Office, as well as Mr. John Jones from the Nevada District Attorney's Office. We at LVMPD support SB 304. Thanks.
Good afternoon, Vice Chair, members of the committee. For the record, David Cherry, Government Affairs Manager for the City of Henderson. We all share a desire to keep our streets safe for drivers, bicyclists, and pedestrians. This legislation sends a strong message to those who choose to drive while intoxicated that you will face serious consequences should you commit a vehicular homicide. We know there's a strong correlation between fatal accidents and driving under the influence of drugs and alcohol, or both. We hope that the adoption of AB 304 will serve as a deterrent to keep people from getting behind the wheel when they are impaired, and should they take a life, that it will mean they are held fully accountable for their actions. For these reasons, we urge your support for SB 304, which will give our courts and prosecutors a law that can deliver justice to victims and their survivors. Thank you.
Thank you so much. And with that, we will move to Las Vegas in testimony in support of Senate Bill 304 and begin when you're ready.
Good afternoon, Madam Chair. My name is Sandy Heverly. I'm the Executive Director and Victim Advocate for Stop DUI Nevada. I've been a resident of Clark County since 1964 and active in the anti-drunk driving mission since 1982. I'm also a multiple DUI victim. I'm here today on behalf of the thousands of innocent DUI victims that we represent. And thank you for the opportunity to testify in support of Senate Bill 304. And thank you, Senator Stone, for sponsoring this very important measure for Stop DUI, a measure we believe will help save lives. While working with thousands of DUI victims in Nevada, across the country and abroad, it quickly became clear that DUI is a crime that crosses all boundaries. race, religion, gender, age, economic background, Democrat, Republican, Independent. It does not discriminate, and no one is immune. The law tells us it's technically a crime against the state. However, in reality, it's the innocent victims who pay the ultimate price. The tentacles on this crime are far-reaching. It tests the emotional, physical, and financial strength of its victims, and at times diminishes human dignity. The experience often leaving bitter, indelible, and debilitating scars on the heart and soul that last a lifetime. This violent crime robs us of our loved ones, destroys families, shatters hopes, dreams, and careers. The devastating aftermath often leads to loss of income and home, emotional and physical trauma, PTSD, chronic depression, divorce when a child is killed, or when catastrophic injury is involved, and sometimes suicide. DUI rapes our state of more than $1 billion per year, and the cost to the innocent victims is immeasurable. By midnight tonight, 749 men, women, and children will have been killed and injured in alcohol-related crashes somewhere in this country. And it saddens me to tell you that Nevada has added significantly to that carnage. And that doesn't even include the deaths and injuries caused by driving under the influence of illicit drugs, prescription, or marijuana, or a combination of all of the above. And rarely does a week go by without a DUI fatality or injury in Clark County or somewhere else in our state. So who are these victims and who will be next? After 4 decades of education, awareness, and providing numerous alternatives, there is no valid excuse. We've reached a point where the penalty for this crime should and must outweigh the risk these drunken fools are willing to take, because they're not listening, as evidenced by the amount of DUI cases seen on a daily basis just in the Las Vegas Justice Court alone. As an example, in February 3rd, 4th, 5th, and 6th, we had a total of 497 DUI cases. That's one court, that's 1 week. Here's the problem, they're not listening. It's become open season on anyone who gets in their deadly path of destruction. Why are we giving them 3 chances to kill us? How many more have to die? How many more families have to be destroyed before Nevada says no to drunk driving and means it? Senate Bill 304 will help us get that message across, and I respectfully request you give favorable consideration to this life-saving bill. And thank you again for the opportunity to express the views of Stop DUI, and thank you again, Senator Stone, for sponsoring this bill for us. I also have we have several other victims here, people who have actually lived the reality of what I have just expressed to you, and so we'll let them speak now.
Good afternoon. My name is Denise Parrish, and my husband was killed April 28th of last year, and his killer is still walking free. And we need this bill passed so that others aren't sentenced to life like I am. The killer, Juan de Leon, has a short pause to his life. I and my granddaughter have a life sentence, and this was because it was his first DUI, not nearly long enough what he's going to serve. He also asked that his time served is taken into consideration. He served 2 days. It will be 13 months that he has walked free before he's sentenced. We need the strength of Senate Bill 304 and will give us, the grieving families, some justice. We beg you to take this action as soon as possible. My granddaughter and I miss my husband, Al Weiss, every day, every minute. Thank you for letting us speak here today, and for those that are not able to speak for themselves anymore. Thank you.
And thank you so much, and thank you for sharing Al with us today.
Hello, good afternoon. I'm the granddaughter of Al Weiss, and DUIs are not talked about enough. We need to put a stop to this for once. My grandfather, Al Weiss, was killed by a drunk driver. My grandfather was doing what he loves most, going out with friends. One night, he went out with one of his friends to get a burger and listen to some music. He later dropped her off, and a little while after, he was hit by Juan De Leon. De Leon was going over 100 miles an hour and twice over the blood alcohol limit. So far, he has only spent 2 days in jail. De Leon has only had one DUI, but that shouldn't matter. He should still be charged with the 25 to life, I believe it is. The 28th of this month will be a year that my grandfather was killed. My grandfather was one of the main pieces in my life. Him and my grandmother have raised me. Now she has to do it on her own without her husband here to help. We seriously need stronger DUI laws. I'm here to support the State Bill 304 along with my grandmother and others that have lost their loved ones to drunk drivers. Thank you.
And thank you.
Thank you, Chair, for allowing us to talk today. My husband, David Prince, along with his co-worker, was killed on April 13th of 2023 at the Mercury test site by a drunk driver who was going between 85 and 105 miles an hour in a government vehicle. The crash was so horrific. It took DNA testing and 15 days to legally identify our husbands. It took 23 months to get him convicted and behind bars. We begged for 1 year more than the minimum. He got 3 to 8 times 2. I'm begging you guys to change the laws. People do not take our drunk driving laws seriously, or they wouldn't be doing it. The crime doesn't fit the punishment, yet the families are the ones that are paying for this. Our lives are the ones ruined, and you never think you're going to be the one until you are. Until it's your loved one. I never thought I would be the one. My kids never thought they would be the one. I have 2 grandchildren that will never meet their grandpa. Please, I'm begging, change the laws. Make people think twice. Make the punishment fit the crime. I appreciate you listening today. Thank you.
Thank you so much, and thank you for sharing your story.
My name is Darlene Post. I am representing my husband, David Allen Post, who was, who was killed by a drunk driver. My husband was so badly burned, it took 25 days to identify his body. The person that killed my husband only got 3 to 8 years in jail. It also took 23 months for him to be put behind bars. I am supporting SB 304 in hopes that future DUI offenders get more of a punishment that fits this crime. I miss my husband dearly. He was my honeybee and I was his honey bunny. We will not get to retire together and plan futures of retiring together. Please, this needs to end and this bill needs to be passed. Thank you.
Thank you so much, and thank you for sharing his story with us.
Good afternoon. My name is Alyssa Bell-Yabbitt, daughter of the fallen trooper Alberto Felix. Driving under the influence is something that not many people know exists. I didn't until it happens to you. It happens way more often than you think. It doesn't just claim lives, it shatters families. I know this because I'm living proof. My family is living proof. On November 30th, 2023, my life changed forever. My dad, Trooper Alberto Felix, was doing what he always did, protecting and serving the community. That night, he and Sergeant Michael Abate stopped to assist a driver who was also under the influence. While they were trying to help another intoxicated driver, Jamarcus Williams came speeding down the road and struck them with so much force that both men were thrown from the scene. Williams didn't stop to help. When he was finally found, hours later, his blood alcohol level was still 2.5 times the legal limit. This is 7 to 8 hours after the crash. But here's what's even more heartbreaking. This wasn't even his first DUI. He has been convicted before, and yet he's still behind the wheel, still making the same reckless choices. If stronger DUI penalties had been in place, real consequences that could have taken him off the road, my father and Sergeant Abate might still be alive today. This isn't just about one man's poor decision. It's about a system that too often gives second, third, and fourth chances until it's too late. We need stronger DUI laws. We need mandatory sentences that actually deter repeat offenders. We need laws that reflect the value of human life, because right now, that system is failing us. My dad was a protector. He dedicated his life to keeping people safe, and it's only right that we honor his memory and Sergeant Abate's by fighting to make our roads safer. By demanding tougher DUI penalties, we're not seeking justice, we're trying to save lives. Thank you.
I am Michelle Abadi, and my big brother and only sibling is Michael Abadi. Sergeant Michael Abadi, and ironically, his Nevada Highway Patrol badge number was 304, just like this bill. Victims like me are automatically given a life sentence with no recourse. The current Nevada DUI vehicular homicide penalty makes me physically sick to read. DUI death with 3 prior like offenses, it feels like it must have been written by a drunk themselves. It's like we're giving these people 3 chances to get behind the wheel and kill someone, and my brother's death is proof of that. Our hometown is Las Vegas, and we need stronger DUI laws. The man that killed my brother, Jamarcus Williams, killed my brother and Trooper Alberto Felix, was a repeat offender of driving under the influence right here in Nevada. This man killed 2 civil-serving people in a single night, leaving them both to die on the road. It should be common sense that if you kill someone while driving a vehicle under the influence, it is vehicle homicide, regardless of your history. There should be no reward by saying you didn't give it a shot 3 times before. It's absurd. I stand here today to urge you to please consider supporting SB 304. And when you see that bill number 304, remember my brother, Michael Abadi, a son, my brother, a husband, and a father who was so unfairly taken from this world because a man who disregarded the law because of the current penalties that he had previously served were far too lenient. My brother and Trooper Felix might still be here today if our laws were harsher. Let that sink in. Please, think about your families and your loved ones and how this could drastically affect you and their lives. The reason I stand before you today is to be the voice for change before they have to say to you, I'm sorry, your family member is dead because of a DUI driver. My brother and Trooper Felix were assisting an unresponsive drunk driver as another drunk driver ran them both over and killed them. Please support the SB 304, and thank you to all those who have worked to get us to this hearing today. I am forever grateful. Thank you.
Thank you. At this time, we will go to our phone lines. I'll remind everyone, we've already hit that 15-minute point, but we haven't gone to the phone lines, so I will go ahead and at least reserve 8 minutes for that. So if we can go to the phone lines for testimony and support, And again, I'd remind everyone that you can always provide testimony in writing to our committee if you have more extensive comments. And we'll go to the phone lines.
If you'd like to testify in support, please press star 9 on your phone to take your place in the queue. Caller with the last 3 digits, 553, please press star 6 to unmute yourself. Once again, caller with the last 3 digits, 553, please press star 6 to unmute yourself.
Hello? I'm
Go-
sorry, can everybody hear me?
We can hear you. Make sure you state your name and spell it
You
for the
can?
record.
Sure. My name is Corlie Ohl. My first name is Corlie, and my last name is Ohl. And I'm alive as opposed to those that just gave testimony that their loved ones died, but I barely made it. I had a drunk driver T-bone my husband and I in our F-150 truck. He was going about 75 miles an hour, and he ran 2 stoplights prior to finding our car. He was heavily intoxicated, 0.29, and that is an hour after that. So I was rushed to the hospital, and I almost died. He hit directly behind my head. So the seatbelt didn't work across my chest, but it did work across my lap. So I unbuckled my seatbelt and I went to the floorboard. There is evidence that my head hit the windshield very hard and cracked it. And I spent 9 days in the hospital with a surgery to remove 7 inches from my small intestine. I live with a huge scar down my belly, and I've never had surgery. I don't have any children, and I have this scar. So I live, and I do believe that he was charged, but he has 5 DUIs, and he was not charged with DUI because he was already serving a prison sentence for breaking and entering, and so they reduced his charge to not include the drunk driver charge. So, anyways, I firmly believe that we have to be tougher on our drunk drivers because we have options. We can call Uber. We can call Lyft. We don't have to get behind the wheel of a car and end somebody's life or change their life forever. That's it. Thank you.
Thank you. Can we go to our next caller, please?
Hello, can you hear me?
We can hear you. Go ahead and begin when you're ready. Please state your name and spell it for the record, too.
It's Brennan, Brennan, Grazioso, Grazioso. I am a program manager with Mothers Against Drunk Driving here in Nevada, and I think it's been so well said by all of the victim testimony on here and all of the organizations and support, but we would just urge the committee to support SB 304 as well.
Thank you. If we can go to our next caller.
Good afternoon, Chair. My name is Jason Woodard with Nevada Sheriffs and Chiefs Association, JASONWOODARD. On behalf of the Nevada Sheriffs and Chiefs Association and the Washoe County Sheriff's Office, I'd like to express our support for this bill. We'd like to thank the bill's sponsor for bringing this bill forward, and like to meet to the previous comments of both the District Attorneys Association as well as the victims been impacted by these crimes. Thank you.
Thank you. If we can go to the next caller.
Chair, there are no more callers in support at this time.
Thank you. Next, we will go to opposition testimony for Senate Bill 304. If you are here to testify in opposition, please come to the table either here in Carson City or in Las Vegas, and please state your name for the record. Welcome back to the legislature, Mr. Pirro.
Thank you, Chair. John Pirro from the Clark County Public Defender's Office. First off, I want to say that every family should be whole that spoke today, and I'm profoundly sorry for their losses. Nothing like that should ever happen. I do want to bring to the committee's attention, in doing research on DUI laws across the nation, we ran a 50-state survey. We actually already have some of the harshest penalties in the nation for DUI. And we are not even in the top 10 for worst states for DUI, which was a surprise because sometimes the rhetoric around the legislature seems to be otherwise. Oklahoma has the #1 harshest penalty, and they are in the top 10 for worst states for DUI still, which is evidence of things that we have talked about frequently in this building, that just merely increasing the penalties does nothing to deter the conduct. Mr. Baumann said in his testimony that we are past the point of public education, but respectfully, we are not. In fact, the National Academy of Sciences has done a deep dive on this and done a very thorough report and went through a number of several factors that would decrease DUIs, which is what we all want here in our state. We are one of 8 states that don't have dram shop liability. Maybe it's time to have that conversation. Maybe it's time to have that conversation for real. We also don't have host liability, and maybe it's time to have that conversation, as that deters conduct. Maybe it's time to start doing stronger server training so that people can recognize the signs of impairment and cut somebody off before they get into a car. Maybe it's time to talk about lowering the blood alcohol content that triggers a DUI, because that actually reduces DUIs. Education and awareness actually could make a serious dent in what we're doing. What also could happen, and this is going to cost money, is high visibility sobriety checkpoints, frequent and often. A DUI court that actually does deep dives into people and their treatment, because close to 50% don't recidivate after their first DUI. So if we did more thorough treatment during that time period, perhaps these things would be even lessened. There are conversations that need to happen this session around DUI death and DUI substantial bodily harm. I feel like those conversations are being truncated, and that has put us in the opposition during this time. I hope we can move to a point where we can discuss a viable solution moving forward this legislative session, even if that includes increasing penalties for certain things here. I deeply respect Senator Stone and the members of this body, and I think we can find a solution, but I think it needs to be a comprehensive solution, not just the continued increased penalty solutions that come through this body. Thank you.
Good afternoon, Paloma Guerrero, P-A-L-O-M-A-G-U-E-R-R-E-R-O. Miss Angela Knott is unavailable today. She asked me to speak on her behalf, so I'm representing the Washoe County Public Defender's Office. The 2 to 20 years contemplated in the penalty here included the consideration of death. So if we're removing death from the charge, and the penalty also needs some adjusting. And we did start that conversation with Senator Stone on what this should look like, but to find an appropriate penalty to account for the spectrum of consequences that needs to be robustly done. Because as Mr. Jones said, there's a wide range of consequences that can happen. And we aren't saying changes don't need to happen, just that we also need to address aspects of traffic laws that need to change and aspects of our dram shop laws that also need to change. Thank you.
I don't see anyone in Las Vegas. We can go to the phone lines for anyone to testify in opposition to Senate Bill 304.
Chair, there are no callers in opposition at this time.
While we're on the phone lines, is there anyone to testify in neutral on the phones?
Chair, there are no callers in neutral at this time.
And do we have anyone to testify in neutral here in the room? Nope, just people getting up and moving. And with that, I will close neutral testimony and call the sponsor back up to give any closing remarks. Do you have anything to say?
Thank you, Madam Chair. I promise I'll be brief. First of all, I want to thank the victims' families for testifying, especially the two troopers. I attended both of those funerals. One of the saddest days of my life. I want to thank you, Madam Chair, for hearing the bill, number one. And number two, I greatly respect my two public defender friends that were up here today. I think they came up with some very good ideas, and I want you to know that I'm readily available to work with them and come up with some amendments if necessary to try to move this bill forward, and I appreciate the committee's consideration.
Thank you for that. And with that, we will close testimony and we will close the hearing on Senate Bill 304. At this time, we will open the hearing on Senate Bill 309. So if I see Senator Steinbeck here present, as well as it looks like we're getting a repeat visit from Mr. Jones. And if I can ask you to just indicate again to the committee what if you are presenting on the bill or the amended version?
Yes, hi. Thank you, Chair Nguyen. We are presenting on the amended version of the bill here today. Appreciate your time and the Senate committee's time. Also, really appreciate the testimony that we just heard. It was very heartfelt and emotional on the last subject. This one is also very closely related. For the record, my name is John Steinbeck, and I proudly represent Senate District 18 in Clark County. And I appreciate the opportunity to present Senate Bill 309 today, which we will do as thoroughly and as briefly as we can for the sake of time today. But this also works on prohibitions of driving under the influence under intoxicated substances. Existing Nevada law prohibits individuals, obviously, from driving or operating vehicles or vessels under the influence of alcohol or specific drugs. However, with increasing prevalence of substances such as fentanyl and other narcotics, updates to these laws have been necessary. Current penalties for offenses involving alcohol and prohibited substance do not adequately deter repeat offenders or address the severity of these actions. Senate Bill 309, and with the amendments, proposes to update these definitions and increase fines and penalties for violations. I'm joined here today with John Jones, as you mentioned, from Clark County, Carly Helbert from City of Las Vegas, and Mark Skifalakwa from Henderson. The last two individuals are joining us from down south. I'll let them, certainly, they're going to give a PowerPoint presentation. As you can tell from the last presentation, though, everybody has been affected by DUIs. I'll just shortly tell you, for me, these are some of the most tragic calls as a firefighter imaginable. They're the ones that are burnt into my head forever. I'll never forget most of them, or any of them most likely. And the worst part is that they're 100% avoidable. So that's what we're aiming to work on here today. I'd like to turn it over to Carly Helbert now for the beginning of this presentation.
Thank you, Senator Steinbeck. Carly Helbert, for the record, CarlyHelbert. We'd like to thank the senator for sponsoring the bill and the committee for hearing it. We do have a PowerPoint. Since this started off as quite a large bill, we've narrowed it down and we'd like to take it slide by slide to kind of make it clear. So the background for this bill is, again, the DUI affects everybody. The annual report of the Nevada Judiciary Appendix reported more than 10,000 DUI criminal filings in 2024. Simply put, DUIs continue to be a significant public safety in the state of Nevada. This did start to, as a very long bill, but we've worked with stakeholders to prioritize 5 policy concepts in the proposed amendment that we will take you through. Specifically, number 1, we're going to request that we reduce the alcohol evaluation threshold. Number 2, add fentanyl to the list of prohibited per se substances. Number 3, increase penalties for subsequent DUIs while a person is in a treatment program per NRS 484C 320 to 340. Number 4, increase penalties on DUI second offenses. And 5, remove phlebotomist testimony required for blood admissibility. And with that, I'll turn it over to Mark.
Thank you, Chair Nguyen and members of the committee. My name is Mark Schifalacqua, Schifalacqua. My first name is spelled M-A-R-C. I'm the head of the criminal division of the city of Henderson, and my office is responsible for prosecuting all misdemeanor DUI cases that happen within the city of Henderson. Last year, we had over 700 new DUI cases that we handled. My thanks to Senator Steinbeck for bringing this important piece of legislation. As a community, we need as many tools as possible to help reduce and stop DUI offenses, and this bill will assist in that effort. The first proposal is fairly straightforward. Right now, under current law, when a defendant has a blood alcohol content of over 0.18, that's over twice the legal limit, the judge must order that defendant to undergo an alcohol or chemical dependency evaluation to determine if they have dependency issues. They are then referred over to a counselor, a licensed person, to evaluate that individual, write a report for the judge, and make some appropriate treatment recommendations. This proposal would simply lower that threshold from 0.18 to 0.16. That's exactly twice the legal limit. This will allow more individuals who are drinking at this high level, likely somewhere between 9 and 11 drinks in a sitting, to be ordered to see if they have a diagnosable issue that can be helped through the criminal justice system, through the sentencing, and through that judge. Overall, this would allow more individuals to be ordered to these evaluations and to get help to try to disrupt this behavior. So the first proposal is really trying to allow more evaluations, more treatment. The second proposal, and I just talked about DUIs involving alcohol. As you know, we have a 0.08 blood alcohol content limit in Nevada. That's usually at least 4 to 5 drinks and then driving. We have similar statutes involving drugs with minimum levels that if you go over, you are per se guilty of a DUI offense, regardless if you are also shown to be under the influence under the law. Just being over a limit means you shouldn't be on our roadways. That's what we said with alcohol and various drugs, including heroin, methamphetamine, PCP, LSD, and amphetamine. And for obvious reasons, we don't want, as a state, people driving with those substances in their systems. But there's one drug that's not on there that we would recommend should be, and that's fentanyl. Fentanyl is 50 times more potent than heroin. It's 100 times more potent than morphine. And heroin and morphine are on this prohibited list already. In 2010, studies showed there was only about 0.6 of DUI drug cases that had fentanyl in the blood, in the system. In 2020, that went to 12%. We're seeing it all the time. And 87% of the samples, the blood samples, actually had another drug mixed in with it. And fentanyl, as you know, when you mix it with something else, drugs or alcohol, it gets even worse. The effects of fentanyl happen quick. And I know you've done a lot of hearings on this and a lot of good work, and you should be applauded for this. But this is one area we think the law might be lagging a little bit and we could update. You should not be driving on fentanyl. The effects are quick. It starts with euphoria and relaxation, but it goes on quickly to drowsiness, dizziness, confusion, muscle rigidity, delirium, and that's if you survive. and this is an extremely deadly substance. All of those symptoms, though, are the worst symptoms to drive on. There is no acceptable level of fentanyl in one system to drive. So we're asking that this be added to the list of the most dangerous offenses, the most dangerous drugs to drive on. And we're asking that the level be put at 1 nanogram per milliliter. And there's a reason for that. That is the generally accepted screening amount that labs test for, that it is in your system. That is through the American Academy and Boards for Impaired Driving investigations. So this is the standard, 1 milligram. Now, I will say that seems low, but it's not. A small amount of fentanyl, as you know, can have huge effects. If you go above 3 nanograms, so we're asking to put it at 1, you go above 3, that's the fatal category. Not everyone certainly will be fatal at that level. Someone could be a heavy opioid abuser, but we've all heard stories of someone taking a drug for the first time and it killing them. That's because of the potency of this drug. The level for heroin, as you see in the NRS, is 50 nanograms per milliliter. And you heard me just say that it's that fentanyl is 50 times more potent. So that's why this number would be appropriate. I'll conclude here by saying that there are only a very few medicinal purposes for fentanyl outside of a hospital. As you know, this is a heavy painkiller and sedative. It is prescribed, but very rarely nowadays, but it can be for breakthrough cancer treatments or end-of-life issues. I will say all of the DUI cases we have involving fentanyl do not involve people who had that through a doctor. The reason I would likely say that is most of those folks just simply wouldn't be able to drive given their extreme pain. This is all illicit fentanyl use. That being said, we do have a protection in there just in case somebody was prescribed fentanyl for severe pain. Doesn't mean they should drive, but you would not be per se guilty just for having it in your system. The prosecutor would have to show you were under the influence under the law. We've made a similar change to vessels for having per se for fentanyl, and we have removed any per se prohibition of MDMA. That was originally in the bill. That has been removed. So we are asking and recommending that fentanyl be put in there. It is likely the most dangerous drug. We're seeing it all the time, and no one should be driving with fentanyl in their system. I want to thank you, and I will be available for questions afterwards. I'll turn it back over to Mr. Jones in Carson City.
Thank you, Chair Wynn, members of the committee. My name is John Jones here on behalf of the Nevada District Attorneys Association, and I'm here to talk to you about sections 12 and 13 of the bill. We've stylized it 2 different ways. One is enhanced penalties for those who commit subsequent DUIs, but really what we're doing here is closing a subsequent DUI loophole. And it does take a bit of explanation, so I do hope that you'll bear with me. When a person pleads guilty or is convicted of their 3rd driving under the influence crime within 7 years, there's only 2 legal outcomes. They either are sentenced to prison by the judge, or alternatively, they can complete a specialty court program we call the Serious Offenders Program. And just so you know, I'll also refer to this as SOP. So Serious Offenders Program or SOP, I'll use that interchangeably during my testimony. SOP is a treatment program, and it takes at least 3 years to complete. And I will admit it is a rather intensive program that requires counseling, monitoring, interlock devices. It's tough. There is a benefit, though, for a DUI, people convicted of DUI to go through the SOP program, and that is the DUI case is stayed while they're in that program. In other words, if they fail to complete the program, the offender is convicted of the felony DUI and sent to prison. But if they're in the program and while they're in the program, they are not a felon. They are not a felon while they are completing the program. And if they successfully completed the program, they are given another misdemeanor. Now, It's a misdemeanor for every purpose in the world except for any future DUIs. If they commit a fourth DUI, they are subject to what we call the once a felon statute, or the fourth time DUI statute. And this gets us to the loophole. If you commit a fourth DUI while you're going through the SOP program, we cannot enhance that. And we can't enhance it because we don't have a judgment of conviction to enhance. So what we're asking for, so in that instance, what we do is we charge the person with another DUI third, when in fact they're eligible for an enhanced DUI fourth. So what we're doing is closing that loophole. The changes in section 12 and 13 allow us to charge a person who is currently attending the DUI treatment court and continues to choose to drive impaired with the enhanced, what we call once a felon or fourth time DUI charges. It almost doubles the penalty if you get your fourth DUI once you've been charged with a felony. So this closes that loophole. We do see this regularly, and it is a problem that we're hoping the legislature will help us solve. With that, I'll turn it over to Carly for the final two provisions that will be left in the bill.
Thank you, John. Carly Helbert for the record. Again, as we heard, continuing DUIs are a problem, and so the next proposal deals with second offenses. Currently, the statute provides that if you are convicted of a second offense within 7 years, you do the first 10 days in custody, or have to do at least 10 days in custody. We are seeking to increase this to 20 days. The reason for this is multifold. First of all, it would make it more consistent with the battery domestic violence second offense penalties. In misdemeanor law, DUIs and battery domestic violences are constantly viewed similarly. Battery domestic violence provides for the 20 days in custody on a second offense. Additionally, it aligns us with other states. Arizona has between 30 and 90 days for a second offense DUI. Washington has between 30 and 45 days, depending on the blood alcohol level for a second offense. And Delaware has a mandatory minimum 60 days on a second offense. We're not trying to trick people into jail sentences. And I think it's worth noting that when a defendant is convicted of a first-time DUI, they are thoroughly canvassed by the judge. They have to go through a waiver and admonishment with their attorney, and they are aware of what subsequent actions will take. We are seeking this increased penalty as a deterrent and an appropriate punishment for somebody who has been told you are not to drink and drive and still does so within 7 years. Additionally, if a defendant chooses to avail themselves to a DUI specialty court, the jail sentence is oftentimes converted to house arrest with additional therapeutic requirements. And per NRS 484C 400, this jail time can also be served intermittently, on weekends, at the discretion of the judge if they deem it appropriate. The final section is section 33, which looks to repeal phlebotomist testimony. It's still going to maintain some civil immunity, but for the most part, we're looking to repeal NRS 484C 250, which requires that a blood test administered under DUI statutes is not admissible unless the blood was withdrawn by a person other than the arresting officer, who is a physician, physician assistant, registered nurse, licensed practical nurse, advanced EMT, paramedic, or phlebotomist, technician, technologist, or assistant employed in a medical laboratory, or has special knowledge, skill, experience, training, and education in withdrawing blood in a medically accepted manner. Now that's a lot of words. What does it mean? So what happens is when a person is arrested for DUI, they are oftentimes taken to the jail or sometimes out in the field. They elect to do a blood test and the blood is withdrawn. There's a phlebotomist, nurse, or EMT there, and I'm going to use that kind of synonymously, who simply withdraws the blood. They don't see the driving conduct, they don't see the FSTs, they don't see the blood test being tested. All they do is take the sample from the defendant. And from the time of the withdrawal of blood to the time of trial can be more than a year. And within that time, that phlebotomist can do hundreds of blood draws. So by the time they get called in for trial, They don't have any recollection of this blood draw. They don't remember the defendant. They don't remember this particular case. What they do is they get on the stand and they basically testify, I am a phlebotomist. Sometimes they might notify signatures, look at documents, but for the most part, they are there to simply say, I am a phlebotomist. And what this means is that there are now less convictions. This is the single biggest hurdle to securing a DUI conviction. And the legislature has demonstrated that DUI convictions are important to public safety. It is one of the few misdemeanors that is enhanceable for 7 years. A record cannot be sealed for 7 years. And most notably, NRS 484C 420 expressly prohibits a prosecutor from negotiating the case to anything other than a DUI conviction unless there are witness or evidentiary issues. And that is exactly what NRS 484C 250 causes, witness issues. These cases are dealt because a phlebotomist is unable to attend court on one of their hundreds of cases, and the case has to be reduced to a lesser charge. It's not a lack of evidence. It's not a bad stop. It's a witness issue where the phlebotomist can't make the trial to simply state, I'm a phlebotomist. It is a burden without a benefit. It puts an obstacle in the way without obtaining anything of evidentiary value. The phlebotomist didn't see driving, didn't see the FSTs, didn't test the blood, and they usually don't remember who the defendant is. They just withdrew the blood, usually in the presence of an officer, and then handed it to the officer for impound. And yet, with NRS 484C 250, they need to come to court every time they are called. And finally, it's a drain on healthcare workers. Again, these are the most frequently subpoenaed witnesses in DUI cases. It doesn't matter if it's an officer, if it's a trooper, if drugs are suspected, if alcohol is suspected, the phlebotomist is there to take the blood. City of Las Vegas ran a report for the EMT who is responsible for blood draws on weekend night shifts. And he was associated with more than 400 DUIs in a year. He was subpoenaed for trial nearly every day there was a court session. And he forewent advanced EMT training because it couldn't fit in his schedule, and he eventually left to pursue another career because it was so unsustainable. There is simply no need for this burden. And so that comes to, I think, which is probably the most controversial question. Is this permitted? Yes, this is a statutory obligation, not a constitutional one. To be clear, there is not a constitutional requirement that a phlebotomist withdraw a defendant's blood in a DUI case. There is a statutory requirement, specifically NRS 484C 250, the statute we are seeking to repeal, that makes it necessary. And because of this statutory obligation, certain constitutional rights attach. But again, it is not a constitutional requirement that a phlebotomist withdraw the blood. Currently, the statute mandates that in a DUI case, the prosecution must provide a statement that it was a phlebotomist or other qualified person who withdrew this blood. This statement can be given through a written affidavit or provided at trial. But this statement has to be entered in order for the blood to be admissible. Because this statement is entered into evidence, the defendant has a constitutional confrontation right to cross-examine the declarant. That's what Reno versus Howard held, that the phlebotomist affidavit or statement entered into evidence at trial is subject to cross-examination. It did not hold that it was constitutionally necessary for the prosecution to make this statement. So the question arises, is the statement that they are phlebotomists necessary? No. And this issue was addressed in Pennsylvania by Commonwealth versus Schaefer, which held that the officer and the lab analyst could provide sufficient testimony to satisfy any confrontation clause issues. The only reason this statement is required now is because the statute mandates it. Now, with the repeal, will the blood results be automatically entered into evidence? No. The prosecution still has the highest burden of proof in criminal proceedings, beyond a reasonable doubt. Repeal of this statute does not change that. Prosecutors still must prove key elements such as chain of custody and must still prove that the defendant had a valid test result. The burden is high and it will remain high. Officers will have to make key observations, including time of the blood draw, that they saw the blood draw, that a non-alcoholic swab was used, and have to testify to the chain of custody. But if an officer can testify to this, and the prosecution can meet its burden of proof, then why do we need the phlebotomist to testify? We don't. That's why we are seeking to repeal this statute, because it creates an unnecessary hurdle without providing any evidentiary or constitutional benefit. It is legally permissible and in the interest of public safety to do so. And finally, I think there's some question about will phlebotomists still be called at trial? Yes. Nothing prohibits the phlebotomist from being subpoenaed to trial. And quite candidly, the prosecution is still probably going to have to call them several times, especially if this is enacted. The officer may not have made all the pertinent observations. If they left the room, they cannot establish what we need to establish to get the blood results admitted. Simply put, they will still be called. The defense can also issue subpoenas for their presence at trial. They may have evidence for their client that the officer did in fact leave the room and want to use the phlebotomist to potentially impeach an officer if he testifies otherwise. At the end of the day, phlebotomists can still be called to trial. It is just no longer mandatory that they be subpoenaed for every trial. Thank you.
And Chair Nguyen, John Jones, on behalf of the Nevada District Attorneys Association, we are available for questions. I do want to say, every section of the bill that does not deal with one of the 5 policy proposals we presented to you, our amendment moves to strike, in other words. So we are just moving forward on the 5 proposals that we've just presented to you. And with that, Chair, I think we are all available for questions.
I guess I'm the one asking questions. I just wanted to start off by saying that I appreciate the sponsor and the supporters of this piece of legislation meeting with me to kind of address some of the concerns that I had with the original language of the bill. So I am happy about that. I guess my other question has to do with this. I guess I'll just kind of start from this. I understand wanting to reduce the concentration of alcohol. Obviously, in opposition testimony from the Public Defender's Office, they even mentioned that potentially reducing like BAC limits has proven results to lower DUIs and DUI deaths, obviously. So I appreciate that. When we talk about the fentanyl, obviously that's something that we address all the time. Is it currently something that no one is testing right now?
Mark Scifalacqua, they are testing for it. So yes, we do have results for fentanyl on our current cases.
And then are you having to proceed under the impairment theory, and are you having difficulty proving those cases under the impairment theory?
Mark Scifalacqua, very good question. Yes, we do, because it's not prohibited and it's not on the list right now. You are limited to the impairment theory. The difficulty with some of these prosecutions with fentanyl is kind of the symptoms that I mentioned. We find many times people are passed out in their vehicles because of the effects of fentanyl. Typically, to prove a case under the influence, you use field sobriety tests, you use different questions, you do observations. Some of those cases can be proven and some not, but we do see some challenges because of the heavy effects of fentanyl.
And then I know that in previous legislative sessions, especially in 2023, we talked a lot about fentanyl. There was lots of discussions about other drugs, like almost every drug, it sounded like, being cut with fentanyl. Do you have any concerns with the level that you're suggesting, which sounds like is what laboratories are testing at, that you may get other medications that are other drugs or anything else that is cut with fentanyl that may not be the primary drug? Not that that wouldn't cause impairment, but do you have any concerns about some of the things that we heard from previous legislative hearings around fentanyl?
Mark Scifalacqua, thank you for the question, Chair. Yes, I think the statistic I mentioned, we do have so many of these cases where fentanyl is not the only substance. Either there could be a cutting agent, but very likely many times there's another drug with it. There's oxycodone or there's cocaine. As you know, sometimes drugs can be laced with fentanyl, which just makes the whole experience worse for the defendant's ability to drive. But we do feel if it's over that limit, you are feeling the effects. And again, if we go too high, as you know how potent this can be, the law wouldn't be as effective.
And then this is probably for you, Mr. Jones. When we talked about the enhanced penalties, I do tend to agree that there's a loophole that if you're in the serious offender program and you pick up other DUIs, would this also apply to people that are on a second DUI that are perhaps in the or moderate offender program or MOP?
John Jones on behalf of the Nevada District Attorneys Association. Yes, this bill also makes the same change to the moderate offenders program. But I'll point out with MOP, technically it requires a conviction prior to being placed into the program. So we made the change in both places just in case, but by the statute, a conviction is required in order to enter MOP.
And I don't think this addresses it, but I know, and this is probably for the two city attorneys, because I know, well, I think everyone deals with so many DUIs, but I know from my experience, you would see, and I think Senator Buck had referred to it before, and we've heard it in numerous testimony from, unfortunately, from victims. Is there anything about this that prohibits people that maybe get 3 DUI firsts in a row?
John Jones on behalf of the Nevada District Attorneys Association. The statute now currently, if I have 3 convictions, I can enhance. It does not matter what order the convictions occurred in. It does not matter what, if the first DUI is the 3rd conviction, it does not matter. So the statute does allow me to enhance. The problem is getting the conviction before the point in the case where you're actually at trial, and that's our issue. So I think this is going to help give us a little bit more flexibility, especially in terms of the enhancement for those in specialty courts that will allow us to instantly seek enhanced penalties. And I don't know if my city attorneys want to add anything to that.
Just to clarify, I'm talking about a situation where someone gets arrested on a DUI, they are in jail, they get released, they go out, they get another DUI. So it's well before even charges have been formally filed. And they get a rapid succession of DUIs. Sometimes someone's in crisis. Is there anything that you all have looked at as far as addressing some of those issues? Just because I know it has come up over and over and over at times about people having so many DUIs and them not being resolved.
Thank you, John Jones, on behalf of the Nevada District Attorneys Association. I actually understand your question, and it is a great question. In terms of enhancements, we're kind of stuck because at that point they're all firsts. But what we have done is when they're up for a detention hearing, their 48-hour Valdez-Jimenez hearing, if we see that they're pending a DUI, we try to expedite the new DUIs so we can get them in front of a judge faster, because clearly they are a threat to the public because they have not stopped driving impaired. So internally, even though the statute doesn't say anything about it, it's silent, our internal process is to seek expedited blood testing so we can get that case filed sooner, ask for a bail, ask for supervision, get release conditions from the judge that will hopefully curtail that behavior.
Thank you. And I don't know if Mr. Shiflaklar or Ms. Hulbert have any question or answers to any of those, or if that covered it. Sounds like.
Mark Skifalakwa, thank you. That did cover it. We do something similar. If somebody is out on a DUI, we're waiting for the blood results, and another one occurs, we do try to expedite that testing so we can file charges and try to prevent this.
Carly Albert for City of Las Vegas. We do the same.
Sorry for all the questions for me. I think, unfortunately or fortunately, I don't know if they are enjoying this or not, but I do obviously have some professional experience in this area. This brings me back to the thing that probably gives me the most concern, and it is repealing NRS 484C.250. In my conversations with you, and you can confirm this, it's my understanding that currently you subpoena witnesses for trial, in anticipation for trial. So currently you're subpoenaing the phlebotomist, the police officer, any other eyewitnesses, the person that did the lab work. Is that correct?
John Jones, on behalf of the District Attorneys Association, yes, that is correct.
And is there a waiver process? So defense attorneys, if they want to, they can stipulate or they can waive the appearance of certain, I guess, witnesses if they choose to.
John Jones, on behalf of the Nevada District Attorneys Association, in terms of stepping to the affidavits submitted by the phlebotomists, in theory, they could stipulate to that. It's my understanding they never do.
Okay. And then I've been told that you issue these subpoenas, and obviously there are some concerns with, like, I heard the concerns from the city of Las Vegas. But just like we've heard in this committee multiple times when it comes to traffic tickets, sometimes these court orders or these subpoenas to appear in court are just disregarded. Is that correct?
John Jones, on behalf of the Nevada District Attorneys Association. Disregard is a strong word. I think one of the toughest jobs as a prosecutor is getting people to come to court. There are a million different reasons why people don't come to court, and it could be sometimes through no fault of their own. But that is always a challenge for a prosecutor, is to get the witnesses we need to prove the case beyond a reasonable doubt in court.
But at the end of the day, if that phlebotomist or that nurse or that person that works in the jail that's taking the blood, they don't appear, you have options as a prosecutor to either issue an order to show cause or try to get that person there, potentially.
John Jones, on behalf of the Nevada District Attorneys Association, we could request the judge continue the case, and if we have proof of service, there are some remedies under law that we could utilize to get that witness there. Yes. I don't know if my city attorneys want to expand on that any.
It doesn't
Mark
sound like.
Skifalakwa, yes, there are certainly remedies that prosecutors have for disobedience of subpoenas. Those are always subject to a court's, agreement with what we're asking to do. That is half the battle, getting the witnesses there. The second part is, what are they saying when they get there? And I think that was some of the point, is very little when they get to court.
I guess my serious concern with repealing a statutory provision that our state has had in place for 50 years to further enhance due process for people accused of a crime is that it sounds like we're doing it because it's like we're rewarding people that don't come to court. Like, if I'm ordered to come to court, I should come to court. And the solution seems very strange to me, that we would just eliminate some of these due process protections in statute to reward someone who just disobeys a court order.
John Jones, on behalf of the Nevada District Attorneys Association, there are 2 points that I want to make. It's my understanding that that cities, municipalities, counties have difficulty finding phlebotomists as we speak. I want to say it's not a job people are clamoring to do, but we have had some difficulties finding them. So, holding phlebotomists in contempt is not going to be a great recruiting tool for counties when we need more of them. That's the first point I want to make. The second is, I think our point is that the goal of this state, the goal of this committee, the goal of this legislature is for us to hold people who are driving intoxicated accountable. We hold them accountable by securing a conviction for driving under the influence. And I think what our practitioners from the city attorneys are saying is that right now, one of the biggest impediments, if not the biggest impediment to securing a DUI conviction, is the appearance of the phlebotomists. And when we do get their appearance in court, they don't even remember drawing the blood. We've got an officer who was present. We may even have the blood draw on body cam. But if we don't have the phlebotomists, we don't have a case. And so what we're asking for is to remove that requirement from statute, and in hopes that we've got body cam, we've got officer testimony that will help us get literally the same testimony into the record, and still help us get more convictions, or at least try to get more convictions. Ultimately, we still have to prove beyond a reasonable doubt that the defendant was driving impaired. And we're still going to have to call the individual who actually tested the blood and found out what the specific BAC was. those people will still be required. Literally, what we're talking about is the person who drew the blood. I don't know if my city attorneys have anything to add.
Partly Halper for the record. I just want to point out that the genesis for this bill is not to reward people who disregard the subpoena. It really comes down to the content of what they're saying. And we're not aware of any other statute that requires somebody who does not remember the case to appear to say what their job is.
I just have concerns. I mean, this is potentially a slippery slope. Like, all of a sudden you'll be like, well, we don't need the laboratory person because they're just looking at vials of like blood and they're processing the blood. Obviously, some of us that have lived in Southern Nevada saw the news where like hundreds of thousands of vials were like corrupted and contaminated, throwing out all those DUIs. And if we had like a similar statute like this, you wouldn't have the ability to like obtain that kind of information about fraud. If the person taking the blood, for example, someone had like rolling veins and had difficulty like taking that blood, I don't know if necessarily the officer or the witness that was just viewing the blood draw would be able to fully answer some of those questions. And, you know, more of a comment than anything. And then, I mean, even, you know, in your slide 16, it says, will phlebotomists still be called at trial? And it says, yes, nothing prohibits the phlebotomist from being subpoenaed from trial. But as a defendant, like, doing that, what's going to stop them from having those same problems? And it seems like it's shifting the burden onto the defendant to be able to prove that they are innocent. And obviously, a tenet of the United States Constitution of America and Nevada is that the burden is on you. So I guess I just have some concerns about that. I don't know if this has created any other questions from the committee. It does not seem like it has. So with that, I will go ahead and, if you have any further comments or statements or anything? Oh, I do have one more. I'm sorry. This is not a part of your bill, but it was brought up by some people that came to my office, and I know that there were some changes to the list of per se limits. And someone had indicated, and I was wondering how many cases that you have with amphetamine. I don't know if anyone has that information or can talk to that, like, particular prohibited substance.
John Jones, on behalf of the Nevada District Attorneys Association. So the current statute, amphetamine,
Yes.
that question was posed to me earlier. I thought the reference was for the addition of MDMA, which we are striking from the bill. So I don't have that information with me today, Chair. What I can do is go back and see if I can pull those stats.
I think that would be appreciated. I had heard that this is actually, like, we think of amphetamine, but I've heard it's like a lot of ADHD medication and some other medication might test that way. And I don't know if these limits are something that is addressing, but if someone's lawfully taking medication, I don't think there's any indication when someone with ADHD is taking this type of medication that they shouldn't be able to drive. So I was wondering if that's something you can maybe get some more information as this bill is working its way through the process.
Thank you, Chair. John Jones on behalf of the Nevada District Attorneys Association. I do want to point out 484C080. So amphetamine that is lawfully prescribed is not a prohibited substance. So we would have to proceed under an impairment theory in that situation, and that's again 484C080. Prohibited substance means any of the following substance if the person who uses has not been issued a valid prescription, and amphetamine is included.
So if someone has that in their blood and they have a valid prescription for that medication, that's a defense that they can already present?
And we would have to proceed under a actual impairment theory.
Kind of answers my question, so. Thank you. I don't see any other questions from committee members. Thank you for your presentation. And if I can ask you to step back, and if you are here to testify in support of Senate Bill 309, I'd ask you to come to the table. And go ahead and begin when you're ready. We'll start here in Carson City.
Good evening, Chair, Senators. My name is Zach Bucher, B-U-C-H-E-R, here wearing two hats. One is the Government Affairs Manager for the City of North Las Vegas. Also here for the Urban Consortium, which consists of the 5 largest cities in the great state of Nevada: Las Vegas, North Las Vegas, Henderson, Reno, and Sparks. I'm sure you'll appreciate it. I will be brief. Appreciate Senator Steinbeck's bill and his efforts to help us keep our streets safer, and we are here today urging your support. Thank you.
Good evening, Chair Wynn and the Senate Committee on Growth and Infrastructure. My name is Chris Reese, RIES. I represent the Las Vegas Metropolitan Police Department. First, I'd like to thank Senator Steinbeck and the other presenters. And if I may, as a point of privilege, it's always good to hear my friend and colleague, John Jones, the esteemed Nevada District Attorney's Office, present not once, but twice in this committee. At LVMPD, we support this legislation and echo the concerns and solutions that were presented. We believe this bill will decrease DUI-related crashes, often the most gruesome and avoidable crash scenes. We support SB 309. Thank you.
Thank you. We'll go ahead and go to Las Vegas. Go ahead and begin when you're ready.
Good afternoon, Chair Wynn, Vice Chair Bazina, members of the Senate Growth and Infrastructure. Good afternoon. My name is Andrew Bennett, and I'm here exclusively in my capacity as Chair of the Nevada Advisory Committee on Traffic Safety. I'm here today to support Senate Bill 309, specifically Section 11 of the bill, which reflects one of NVAC's 10 critical policy priorities, which is increased screening and assessment for individuals involved in impaired driving offenses. Section 11 of SB 309 lowers the threshold, as discussed. From a traffic safety perspective, early identification of substance use disorder is critical. By ensuring that more individuals receive professional evaluations, we create opportunities for intervention before a tragic crash occurs. This provision supports a public health approach to impaired driving, one that emphasizes treatment of recovery and doesn't rely on incarceration alone. If we're serious about talking about DUIs, which I appreciate the conversation that we've had over the last several weeks and several sessions, I think that this is a great start. So we support this bill. Thank you.
Thank you. And if we can go to the phone lines now for testimony in support of Senate Bill 309.
If you'd like to testify in support on SB 309, please press star 9 on your phone to take your place in the queue.
Good evening, Madam Chair, members of the committee. Jason Woodard, Jason Woodard, representing Nevada Sheriffs and Chiefs and the Washington County Sheriff's Office. We would like to encourage your support of this bill. I'd like to thank the bill sponsor for bringing this bill forward. We believe these changes to the current DUI laws are necessary and would be effective in helping us reduce these crimes. Thank you.
Hi, Brennan Grazioso from Mothers Against Drunk Driving, BRENNAN GRAZIOSO. As said in previous testimony that we heard today, this could definitely strengthen some DUI laws here in Nevada. And so we would urge the support of SB 309. Thank you.
Chair, there are no more callers in support at this time.
Thank you. If this time we can go to testimony in opposition of Senate Bill 309. I'd ask you to come up to the table and begin when you're ready.
Paloma Guerrero, PALOMAGUERRERO, on behalf of the Washoe County Public Defender's Office today. We have two concerns with the bill. I'll speak on their first concern, which is with Section 12, which extends the mandatory jail time from 10 days to 20 days for second DUIs. Instead of jail time, we are failing to consider resources or treatment options that would be better for that person and also curb any sort of behavior that might stop them from driving drunk. I think we all have the same goal here, which is what can we do to stop this behavior? Our concern is that the person getting that second DUI, and we understand that that person made choices and that they need to have consequences, but changing it to 20 days without any sort of evidence to show that this is going to help, without any research to show that this is going to decrease DUIs or stop someone from drunk driving is not fixing the problem. We're putting a Band-Aid on it that we don't know will actually heal that wound and can potentially exacerbate that wound and lead to more bad choices. 20 mandatory days in jail is significant. It's enough to lose a job, to get behind on your bills, to get behind on your rent, and we would be stripping people of the support that they need in order to curb an addiction that they probably have. And I'll turn it over to my colleague for her second concern.
Thank you, Chair. John Pure from the Clark County Public Defender's Office. The one section that I wanted to talk about, and we have brought this to the Senator's attention, is the section of the bill that's seeking to remove calling the phlebotomist in to testify. That law has been on the books for close to 50 years. It was passed in the 80s. This body saw fit to add these protections in. And I want to talk about the right of confrontation. The United States Supreme Court has said that the right to confront an accuser throughout the trial process is fundamental to our American legal system. It is called the greatest legal engine ever invented for the discovery of truth. This is the law that they seek to repeal in this bill. And when you remove the ability to challenge evidence and challenge the person collecting the evidence, what you remove is the ability to evidence to be fairly and accurately taken in by the court or the jury. You remove the ability to challenge the inaccuracy of the evidence, the incompleteness of the evidence, maybe the misleading evidence that could be admitted. Was the sample taken wrong? Were proper procedures not taken by the phlebotomist? Was once the blood was taken, was it shaken and not inverted as it's supposed to be properly done? Was the process flawed? We can't lower the state's burden to make things more convenient because the state isn't having their witnesses show up to court. It's fundamental to our American system of justice that we have people show up when we're going to have a trial. There was a time where the city attorneys told this body that if we had jury trials for domestic violence cases, the whole system would collapse. It did not collapse, and frankly, we don't have a lot of trials. There's not a lot of DUI trials. There's not a lot of domestic violence trials wholesale across the state. The system has not collapsed because we are calling people into court. So there's no reason to remove a law that's been on the books for 50 years and allows people who are accused of a crime to confront their accusers. What they want really is hearsay evidence, an officer to tell you what the phlebotomist did. And any parent who has children knows that when their kid said they said, you're like, who's they? Who is they that said that? They stop that right there. And what the state is asking you is to allow that now. And what we're saying is don't repeal that. Otherwise, there are provisions in this bill that give us no heartburn.
Mr. Pirro, do you mind staying there? Senator Hansen has a question for you.
Real quick, nice to see you again.
You as well, Senator.
The section of the bill you're talking about that you would, if we took it out, what section is that specifically you guys are talking about?
The section that talks about NRS 488.500.
Okay, the same one the chair had the issue then. Because I'm just thinking, it's the last day, if the sponsor of the bill wants to maybe get the bill moved, if he would be willing to take that out. It sounds like if that is taken out, that's one of the main concerns both you and the chair have.
Yes, Senator.
So I'm just kind of saying, want to,
would-
last minute Hail Mary pass, I guess I'm offering here, so.
I would withdraw the opposition.
Okay, thank you.
If we can go to the phone lines for any testimony in opposition to Senate Bill 309.
Chair, there are no callers in opposition at this time.
While we're on the phone lines, do we have any testimony in neutral?
Chair, there are no callers in neutral as well.
I will call anyone up to the table that's here to testify in neutral. Seeing none, do you have any further closing statements to make? Okay, with that, we will close the hearing on Senate Bill 309. And if we can just be in a brief recess before we start these work session things, and if I can ask Senator Steinbeck to hold back for a second. Okay, I will bring us back into order. And at this time, I will open the agenda item on work session. Because Senator Steinbeck is still here, I'm going to start with the work session on Senate Bill 309. At this time, I will turn this over to Ms. Julian King.
Thank you, Chair Nguyen. For the record, Julian King, Committee Policy Analyst with the Legislative Council Bureau. Just to note, as nonpartisan staff, I cannot advocate for or against any measure that this committee will consider. So Senate Bill 309 is sponsored by Senator Steinbeck and revises provisions regarding driving under the influence of alcohol and prohibited substances. And as discussed during the bill hearing, an amendment was proposed by the Nevada District Attorneys Association, which was further amended by Chair Nguyen to reduce the concentration of alcohol threshold from 0.18 to 0.16, add fentanyl to the list of per se substances, change on or off the highways of the state to a highway or on premises to which the public has access, to use consistent verbiage throughout the DUI statutes, increase the incarceration time on a second DUI offense from 10 days in jail to 20 days in jail, allow for enhanced penalties when a subsequent DUI is obtained while a person is undergoing a program of treatment for an alcohol or other substance use disorder pursuant to NRS 484C.320, 484C.330, or 484C.340. And all other proposed changes contained in SB 309 would be removed from the bill per this amendment. Thank you, Chair Nguyen.
And I'm sorry, that was an amendment from the District Attorneys Association.
Oh.
I think the only amendment that I'm suggesting is the repeal of section. And I see Mr. Jones here, if you could clarify
Yeah,
further.
so that would be, of the 5 policy proposals, Chair, that would be the 5th one. You're striking that from our amendment. As well, in the amendment that we sent to Nellis, there's actually 6 policy proposals. One of them is changing on or off the highways of the state to a premises to which the public has access. We've actually struck that from the bill as well. Okay. So it'll just be the 4 policy proposals, reducing the threshold, fentanyl per se, the specialty court cleanup, and the 20 days for a second. And I apologize, John Jones on behalf of the Nevada District Attorneys Association, I apologize for not cleaning that up during our testimony.
We're going to start all over again. So we are back on the work session on Senate Bill 309. Again, I'm going to turn it over to Ms. King to go over the provisions, the amendments, and then the additional amendment today, striking the 5th policy recommendation in the District Attorneys Association amendment.
Thank you, Chair Nguyen. Julian King, Committee Policy Analyst for the record. So the amendment submitted by the District Attorneys Association will reduce the concentration of alcohol threshold from 0.18 to 0.16, add fentanyl to the list of per se substances, increase the incarceration time on a DUI, on a second offense DUI, from 10 days in jail to 20 days in jail, allow for enhanced penalties when a subsequent DUI is obtained while a person is undergoing a program of treatment for an alcohol or other substance use disorder pursuant to NRS 484C.320, 484C.330, or 484C.340. And then all of other proposed changes contained in SB 309 to be removed from the bill. And thanks.
Perfect. Thank you for your patience with us as we're trying to do this on the fly. With that, are there any questions about this work session? Seeing none, I'd entertain a motion.
So moved.
Do I have a motion from Senator Pazina, a second from Senator Buck. Any other further discussion? Seeing none, all those in favor say aye. Aye. All those opposed say nay. It carries unanimously, and I will assign that floor statement to Senator Steinbeck. Next, I will hear another, kind of going out of order, another Senator Steinbeck bill. If we can go to Senate Bill 113. Oh, I'm doing this thing where I'm keeping everyone on their toes, and they're gonna hate me.
Thank you, Chair. Senate Bill 113 adds occupational therapists and physical therapists to the list of people who can certify that an applicant for a special license plate, placard, or sticker issued by the DMV is a person with a disability. The bill is sponsored by Senator Steinbeck and was heard on February 19th. The Nevada chapter of the American Physical Therapy Association proposed an amendment to indicate that nothing in the bill's provisions restricts a licensed provider from designating a member of the care team from filling out the forms under the oversight of the practitioner. Thank you.
Do we have any questions? Seeing none, I'd entertain a motion.
So moved. Second.
I have a motion from Senator Pazina, a second from Senator Hansen. Any further discussion? Seeing none, all those in favor say aye. Aye. Anyone opposed say nay. Motion carries, and I will again sign that floor statement to Senator Steinbeck. Next, we will move, I will just go down the order of the work session document as posted on the agenda, on the first revised agenda. The next bill we will go to is Senate Bill 180. Ms. King?
Thank you, Chair. Julianne King, Committee Policy Analyst for the record. Senate Bill 180 establishes a minimum liability insurance requirement for certain motor carriers in Nevada. The bill is sponsored by Senator Flores and was heard on April 2nd. The Nevada Justice Association proposed an amendment to establish staggered minimum liability insurance requirements as follows: $1 million beginning January 1st, 2026, $1.25 million beginning January 1st, 2028, and $1.5 million beginning January 1st, 2030. Thank you.
Any questions? Seeing none, I'd entertain a motion. I have a motion from Senator Danyate. Do I have a second?
Second.
Second from Chair Pazina, or Vice Chair Pazina. We have a discussion. Go ahead, Senator Hansen.
Thank you, Madam Chair. I'll be a no on this. I think the amounts are still excessive. The federal government only requires $750,000. There's only one state out of the 50 states that actually go to anything close to this. So I think our current policies are fine, and I don't think I think we're trying to solve a problem that isn't there. And the amount of evidence that they produced that there's a huge problem just wasn't there and doesn't warrant this kind of a dramatic increase in costs to all the people that need this type of insurance. So I'll be a no. Thank you, Madam Chair.
Senator Brock?
I'll be a no today because it seems to punish Nevada-owned businesses, and I don't see why it would prevent you from not just going and opening a company in a neighboring state who doesn't have this provision and cross into Nevada. Oh.
Thank you. Any further discussion? Seeing none, all those in favor say, oh wait, were we in questions or discussion?
You were right, discussion.
Okay, we're discussion. All those in favor say aye. Aye. All those opposed say nay. We have a nay from Senator Hansen and Senator Buck. But the motion carries, and I will sign that floor statement to Senator Flores. If we can move on to the next bill, which is Senate Bill 194. Ms. King?
Thank you, Chair. Julianne King, Committee Policy Analyst for the record. Senate Bill 194 revises provisions related to short-term leases of passenger vehicles. The bill is sponsored by Senator Scheibel and was heard on April 7th. Senator Scheibel proposed an amendment to replace the current language of the bill with language that requires all short-term vehicle renters in Nevada to provide proof of personal automobile insurance that meets state minimum liability requirements. If an individual lacks insurance, the rental company may offer or refer the renter to a third party that offers optional temporary insurance coverage. The amendment also prohibits short-term lessors from engaging in any unfair, deceptive, or coercive conduct to induce a renter to purchase a waiver of damage, optional insurance, or any other optional good or service.
Thank you. Do we have any questions about this? I'll remind everyone this is a gut and replace kind of bill. So any questions? Seeing none, I'd entertain a motion to amend and do pass.
So moved.
I have a motion from Senator Pazina. Do I have a second? A second from Senator Danyate. Any further discussion? Go ahead.
Thank you, Chair. I really like this bill because anytime we can help with the whole uninsured motorists and ensuring that people have insurance, because that does cost Nevadans a lot. So thank you so much for this bill, Ms. Scheibel.
Thank you. Seeing no further discussion, all those in favor say aye. Aye. All those opposed say nay. Passes unanimously. I will assign that floor statement to Senator Scheibel. Next, we're moving on to Senate Bill 326. Ms. King.
Thank you, Julian King, Committee Policy Analyst. Senate Bill 326 requires certain public utilities to submit an annual report to the PUCN relating to the condition of the utilities infrastructure. The bill is sponsored by Senator Cruz Crawford and was heard on March 24th. An amendment was proposed by Senator Cruz Crawford to revise the information to be included in the report.
Any further questions? Seeing none, I would entertain a motion to amend and do pass.
So moved.
I have a motion from Senator Pazina, a second from Senator Hansen. Any further discussion? Seeing none, all those in favor say aye. Aye. All those opposed say nay. Passes unanimously, and I will assign that floor statement to Senator Cruz Crawford. Ms. King, if we can move on to Senate Bill 359.
Julian King, Committee Policy Analyst. Senate Bill 359 revises provisions governing civil infraction procedures and requirements in Nevada. The bill is sponsored by Senator Scheibel and was heard on April 7th, and there are no amendments.
Does anyone have any questions about this? I know that Senator Scheibel is continuing to work on this, but we would like, as we have a deadline week, to try to keep this moving along. So there are no amendments at this time to this bill. Do we have any further questions? Okay. At this time, I'd entertain a motion to do pass.
So moved.
I have a motion from Senator Hansen, a second from Vice Chair Pazina. Do I have any further discussion? Go ahead, Senator Buck.
Thank you so much, Chair Nguyen. I'm going to be a yes today, however, reserve my right when we see this all vetted out. Thank you.
Thank you. Any other further discussion? Seeing none, all those in favor say aye. Aye. Anyone opposed say nay. Carries unanimously, and I will assign that floor statement to Senator Scheibel as well. Next, Ms. King, if we can move to Senate Bill 382.
Julian King, Committee Policy Analyst. Senate Bill 382 revises provisions relating to the registration of trailers. The bill is sponsored by Senator Hansen and was heard on March 26th. An amendment was proposed by Chair Nguyen, which replaces the current language of the bill with language that narrows the type of trailers eligible for the registration provisions introduced by the bill to those primarily used in the transportation of livestock, agricultural products, or ranch or farm machinery or supplies to or from a ranch or farm, and provides that registration for certain eligible trailers be for a period of 5 years, and further provides that the amount due for such a registration be equal to the amount that would be due if the trailer were registered for 1 year and renewed for 4 consecutive years thereafter.
Do we have any questions? Seeing none, I'd entertain a motion to amend and do pass.
So moved.
Second.
I have a motion from Senator Pazina, a second from Senator Hansen. Any further discussion? Go ahead, Senator Hansen.
I just want to thank you for moving the bill. The original fiscal note was $99 million. So maybe it'll end up in finance, I don't know. Anyway, the amendment is going to try to help dramatically reduce that, and we are working with DMV and Sean, so hopefully by the time we get to finance, if it gets there, that we'll have this thing worked out to where it's a little more reasonable. So thank you for bringing the bill.
Kind of want to leave it at that 99 million, see what Senator Don Daraloop has to say about that. Seeing no further discussion, do I have seeing I have no further discussion. All those in favor say aye. Aye. Anyone opposed say nay. Motion, or it passes unanimously, and I will assign that floor statement to Senator Hansen. If we can move now next to Senate Bill 395, and with this, I will turn this over to Ms. King.
Thank you, Chair. Julian King, Committee Policy Analyst for the record. Senate Bill 395 prohibits certain autonomous vehicles from being operated on state highways without a human operator present. The bill is sponsored by Senator Orenshaw and was heard on April 2nd, and there are no amendments.
Sorry about that. Any questions on this? Seeing none, entertain a motion to do pass.
So moved.
I have a motion from Senator Pazina. Do I have a second? Second from Senator Danyate. Any discussion? Go ahead, Senator Hansen.
Thanks, Madam Chair. No, I'll be a no on this. Obviously, we want to help the folks out that are going to go through some adjustments as this sort of technology goes forward. However, the way this is structured, it isn't going to do anything that will really help in that regard. May in fact harm this growing industry, so I'm definitely a no on this one.
Senator Buck?
Thank you, Chair Nguyen. When I think of autonomous, it definitely means no driver. And so just over the holidays, I was in Arizona and was driven around by a car that had no driver. And I think that as technology improves in that, we need to adjust, especially when it comes to the workforce. And so I'll be no today.
Thank you. Seeing no further discussion on the matter, all those in favor say aye. Aye. All those opposed say nay. I have a nay from Senator Hansen and Senator Buck, and the motion carries. And I will assign this floor statement to Senator Orenshaw. Next, if we can move to Senate Bill 416.
Julian King, Committee Policy Analyst. Senate Bill 416 replaces the current restricted driver's license available to participants of the 24/7 sobriety and drug monitoring program with a new 24/7 privilege, which allows participants to drive without previously imposed limitations, provided they comply with program requirements, among other provisions. This bill is sponsored by this committee on behalf of the Joint Interim Standing Committee on Growth and Infrastructure and was heard on April 7th. An amendment was proposed by Andrew Bennett, Chair of Nevada Advisory Committee on Traffic Safety, to remove references to mental illness in Section 7 and add language making the bill effective on the date on which the Director of the DMV notifies the Governor and the Director of the LCB that sufficient resources are available to carry out the bill's amendatory provisions. Thank you.
Sorry, keep doing that. I see Mr. Bennett in the audience, I believe, in Las Vegas. So does anyone have any questions regarding the amendment? Seeing none, I would ask for a motion to amend and do pass Senate Bill 416. So moved. I have a motion from Senator Pazina, a second from Senator Buck. Any further discussion? Seeing none, all those in favor say aye. Aye. Anyone opposed say nay. And I don't see anyone here. And with that, it passes, and I will assign this floor statement to Senator Pazina. Next one, we will move to Senate Bill 417. Ms. King.
Thank you, Chair. Julian King, Committee Policy Analyst for the record. Senate Bill 417 requires the PUCN to adopt regulations allowing natural gas utilities to apply for approval of alternative rate-making plans. This bill is sponsored by this committee and was heard on April 7th. An amendment was proposed by Southwest Gas, which authorizes the PUCN to design methodologies for how formula rates are structured, allows a utility to propose an alternative rate-making plan alongside a general rate case or within 6 months after the most recent one, provides that if a plan allows a utility to recover capital expenditures outside of a general rate case, the utility must prove those were prudent, either in a future rate case or at another time set by the Commission, provides that if a utility serves multiple major geographic areas in the state, the PUCN must conduct at least one consumer session in the county with the largest population of each area served by the utility before taking action on its application, and provides that if the PUCN approves a plan with modifications, the utility has 30 days to accept or reject the modified plan. Thank you, Chair.
I just want to confirm that this amendment also includes what the presenters had indicated they had intended to bring in the process for bringing in public comment and public hearings. I'm seeing some of the sponsors of the bill nodding their heads. So Ms. King, is that also included in there? If it is not included in there, I want to make sure that it was included in there because I don't think it was in the original amended document.
It was, this is related to if there's certain multiple major traffic areas, they do one consumer session.
Okay, I missed that part where you talked about the consumer session, so I appreciate that and clarity. Do we have any other further questions? Seeing none, I'd entertain a motion to amend and do pass Senate Bill 417. I have a motion from Senator Hansen. Do I have a second? Second from Senator Iñate. All those in favor say aye. Aye. All those opposed say nay. The motion carries unanimously, and I will assign that floor statement to Senator Hansen. Next, we will move to Senate Bill 442.
Julianne King, Committee Policy Analyst for the record. Senate Bill 442 requires the PUCN to adopt regulations requiring public utilities to submit monthly reports to the PUCN that include the total number of service terminations from the previous month and other information such as the zip codes of affected residences. This bill is sponsored by this committee and was heard on April 7th. An amendment was proposed by Olivia Tanager, Director of the Sierra Club Toyabe Chapter, to revise the frequency of reporting requirements from monthly to quarterly, require the reports to be made publicly available, and specify that the reports include the number of monthly service terminations during the previous quarter. Thank you.
Thank you. Do we have any questions about this? Seeing none, I'd entertain a motion to amend and do pass 442.
So moved.
I have a motion from Senator Pacina. Do I have a second? Second from Senator Dignate. Do I have any discussion on the motion? Go ahead, Senator Buck.
Thank you so much. I'm going to be a yes today, however, reserve my right just to kind of vet this out. I don't, with it not drilling down to the actual people, I don't see how they can really help aside from cast a wide net, which is what they're probably doing now anyway. So I'll be a yes, but reserve my right.
Any further discussion? Seeing none, all those in favor say aye. Aye. Anyone opposed say nay. Motion carries. And I will assign this floor statement to Senator Scheibel. Next, that brings us to, yes, Senate Bill 304. That was heard today. Does anyone have any questions about what we heard today? Seeing no questions, I'll turn this over to Ms. King.
Thank you, Julianne King, Committee Policy Analyst for the record. As we heard today, Senate Bill 304 is related to the crime of vehicular homicide. It is sponsored by Senators Stone, Hansen, Buck, and Krasner, and was heard today, April 9th. And an amendment was proposed and presented during the hearing.
Any further questions? I see, I forget to turn it off, you guys. That's the problem. I'd entertain a motion to amend and do pass Senate Bill 304. I have a motion from Senator Hansen. Do I have a second? Second, someone. A second from Senator Buck. Okay. Any discussion on the matter? Go ahead, Senator Buck.
Thank you, Chair Nguyen. I had texted my sister that this bill was being heard. She was hit by a DUI driver who had 4 prior convictions. And so anyway, thank you so much for your bravery, Corley, and thank you so much to this committee for passing out this bill. Thank you.
No further discussion. Maybe now it will. All those in favor say aye. Aye. All those opposed say nay. It does pass out now unanimously from committee. And I will assign that statement to, our floor statement to Senator Stone. I think that brings us to the end of the work session document. And at this time, I will go ahead and open up the last agenda item, which is public comment. If you are here to testify in public comment, I'd ask you to come up to the front. I don't see anyone running up to the front. Or in Las Vegas, can we go to the phone lines for testimony in public comment?
Chair, the public line is open and working. However, there are no callers at this time.
Thank you. And at this time, I will close public comment. Thank everyone. This has been a pleasure. We're about to make our way through the last committee, first committee house passage. I don't anticipate we'll have a hearing on Friday, but keep in mind, things can always pop up. And with that, meeting adjourned.